All right, I got it.
Good afternoon, everyone. I hope you're all well this afternoon.
Good afternoon, Your Honor.
Good afternoon, Your Honor.
Ms. Bridgewater, good afternoon. Can you tell us when the SAP calendar reset will be?
December the 20th.
Good afternoon, Judge Morrow.
Good afternoon. How are you all doing?
Pretty good, thank you. Whenever you're ready to start, we'll be starting with position 2, Mr. Berry, whenever you're ready.
Okay. And who's representing Mr. Berry?
This meeting is being recorded.
Your Honor, before court begins, I would just like to make the court aware that there is a plea for position 13 Jones. I'm preparing the paperwork now. Who is at the courtroom to receive the paperwork for the plea?
It'll be Officer Norris.
Great, thank you.
You're welcome.
All right. Let's see. I'm sorry.
Your
Tell me
Honor,
again.
I just wanted to add that we have another plea for position number 7, and I just sent that plea paperwork to Norris as well.
Okay. Thank you, Ms. Salette. Ms. Bronstein, are you representing Mr. Berry?
Yes, Judge.
Okay, very good. Thank you. Good afternoon, Mr. Berry. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Berry, you have been charged in case 22 CR 008118H with theft by shoplifting. Is there a history, Ms. Roberts?
Good afternoon. Yes. He has a total of 49 cycles. Last arrest was May 15, 2021 for theft by shoplifting. He does have an open case for a false report of a crime. That case number is 22 SC 181210. 1 FTA from 2015. A 2016 conviction for possession of a firearm by a convicted felon or first offender probationer. 2009 possession of cocaine conviction and possession of marijuana less than an ounce conviction. 2009 possession of cocaine conviction. 2008 sale of cocaine conviction. 2006 willful obstruction of law enforcement officer conviction. 2006 theft by taking. 2005 burglary. And 2004 theft by receiving stolen property conviction. two parole violations, 2016, 2017. And nothing further to add.
Thank you. Good afternoon, Ms. Salet.
Good afternoon, Your Honor. On December 3rd, 2022, Officer Moya responded to a Family Dollar at 1723 Lakewood Avenue in Atlanta. Upon arrival, the officer spoke with the reporting party, who was the manager, Khalil Hood. Mr. Hood stated that the defendant was inside of the store and saw him placing items underneath his clothing in an attempt to conceal the items. Upon Officer Moya's arrival, he waited for the defendant to exit the store with those items, and the defendant did attempt to exit the store. The concealing of the items was on video, and the items that he did attempt to conceal were laundry detergent, air fresheners, and hefty trash bags. The defendant does have prior criminal theft by shoplifting convictions, one from 1995, one from 2007. He does have 50 arrest cycles in total, dating back to 1985. I also saw 2001 and 2015 failure to appear arrests as well. Due to the defendant's history, the state would argue that he poses a risk of reoffending and has shown a pattern of theft. The state would also argue that he poses a risk of not appearing for court in the future based on his prior FTA arrest as well. The state would be requesting a $1,000 surety bond, stay away from the incident location, and no alcohol, drugs, or weapons while out on bond.
Ms. Bronstein?
Your Honor, Mr. Berry is 58 years old. He is a resident of Atlanta, and I noted that the address he gave me is not the address that's in Odyssey. There's someone I should give the updated address to. I just want to make sure that any court notices are sent to the right place.
Would you put it in the chat when you have a chance, Ms. Bronstein, and we'll make sure that it's directed accordingly. Thank you.
Yeah, I'll do that just after this. And Mr. Berry is from Atlanta. His whole family is here. When he works, he does odd jobs in construction. However, his mother is handicapped and she does need someone to stay home with her. And for a little over a year, he has been working as he's been a caretaker for his mother and has not been working. As the court heard, it's not like he was at Lenox Mall stealing expensive sunglasses. What Ms. Salet did read were very practical, not expensive things. And he is in a dire financial situation due to the health concerns. They don't really know what to do right now. He says that he cannot make any bond, but he does need to get out to take care of his mother. He is very worried about her, and he is asking the court to consider a signature bond in this case.
All right. It's going to be a $2,000 signature bond through the jail. Stay away from the incident location on Lakewood Avenue, and no drugs, alcohol, or weapons while out on bond. I'm going to let you out, but if you don't show back up for your next court hearing, then I'll put a warrant out for you, okay?
You won't have to worry about that, sir.
All right. Very good,
Thank
Mr.
you.
Dillon.
All right, thank you, Mr. Martin.
Good luck to you, sir.
Thank you, Ms. Bronstein. Yeah. Ooh, I'll get on tomorrow.
Position 5, Burton.
Your Honor, may the state make a request of the defense?
Yes, good afternoon, Ms. Falk.
Good afternoon, Your Honor. The state would request that the PD's office just let us know if this person has qualified for the services of the public defender or will not qualify going forward.
Okay, he qualified.
Okay, so Mr. Berry did qualify. With Ms. Falk's request, if you could just let us know so that we'll be aware. Whomever the public defender is representing the person today. All right, anything further, Ms. Falk?
That's all, Your Honor. Thank you.
You're welcome. Who do we have next? Mr. Burton? Is
Yes.
this Mr. Burton? Okay, good afternoon. Good afternoon, Mr. Burton. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Oh, yes, sir.
Okay, thank you. Mr. Burton, you've been charged in case 22 CR 008-120Y with theft by taking and criminal trespass. Is there a history, Ms. Roberts?
He had 91 cycles. I saw 2 FTAs. I saw at least 15 criminal trespass convictions that were listed on the GCFD. 3 disorderly conduct convictions, with the last one being in 2018. 3 theft by shoplifting convictions. I'm showing the last also in 2018. A possession of a controlled substance conviction, 2003. He's also a multi-state offender. He has some cycles out of California. The last was in 2000. That was a conviction for sale of liquor to a minor. A grand theft, 1986, out of California, and nothing further.
Ms. Salette?
Yes, Your Honor, on November 12th, 2022, officers reviewed cameras at the Georgia Tech campus and observed that the victim in this case, Miss Rachel Watermeyer, that's spelled Watermeier, put her bag against the wall of the Bobby Dodd Stadium near Gate 9 at 155 North Avenue, Atlanta in Fulton County. Officers then observed the defendant approach the bag, go through the contents of the bag, and then leave the area with that bag walking south on Techwood Drive. The officers were able to use facial recognition software to pull up the mug shots, 2 mug shots of the defendant from the Fulton County Jail. And they were able to come up with his identity that way. The officers also noted that they had encountered this defendant on Georgia Tech's campus before, wearing the same necklace that he was wearing in the video on the day of the theft. As you heard, Your Honor, this defendant has 70 arrest cycles out of Georgia starting back in 2001, and 22 arrest cycles out of California starting back in 1980. He does have a 2019 FTA arrest and 3 2019 criminal trespass convictions. 2 of those were from Georgia Tech campus, and 2 2018 criminal trespass arrests that were amended to disorderly conduct, which were later became convictions. One of those disorderly conducts was on Georgia Tech's campus as well. So the state would argue that he does pose the risk of reoffending and has a pattern of going back to Georgia Tech's campus. And now that he's taken someone's belongings, he is a danger to the property of others. The state would be requesting $1,000 surety bond on each charge, $2,000 surety bond in total, stay away from the incident location, no contact with the victim, and no alcohol, drugs, or weapons while on bond.
Ms. Bonstein?
Thank you, Your Honor. Mr. Burton does qualify for the Public Defender's Office. He is 59 years old. He is originally from California. However, he moved here some years ago to be with his family. His sister is local. So he came to visit, stayed due to the family ties and the family who all lived here. He is a high school graduate. He has unfortunately been unable to find work recently, and as such, he is unable to afford a bond, and he is requesting that the court consider a signature bond in this case.
For the theft by taking, it's going to be a $500 good bond. For the criminal trespass, a $500 good bond, making for a total of a $1,000 good bond. No further contact with Ms. Watermeyer. Stay away from the incident location, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Burton.
Okay. So should we go on?
No. Position 7, Cooper. Cooper, come have a seat.
And Your Honor, Mr. Cooper is going to be a pro se plea.
Okay. And are we ready for Mr. Cooper's plea? Has the paperwork been completed?
Yes, it has been, Judge.
Okay, very good. Good afternoon, Mr. Cooper. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video? Can you hear me, Mr. Cooper?
Oh, yeah.
All right, can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yeah.
All right, you can put your hand down. Thank you, Mr. Cooper. You've been charged in case 22 CR 008122C with criminal trespass. Mr. Cooper, you have a right to remain silent. Anything you say can be used against you. You have the right to have an attorney represent you at these proceedings. It is my understanding that we have provided you with the public defender to represent you this afternoon, and you would not like to utilize their services, but you would like to proceed pro se, meaning without the advice of a lawyer. Is that correct?
Yeah.
Did you hear my question, Mr. Cooper? You wish to appear without the advice of a lawyer?
Oh, no.
Okay, well, we provided you with the public defender. It's my understanding that you wish to take a plea this afternoon, and the public defender is not recommending that, but you would like to go forward on your own to take a plea to criminal trespass. Is that correct?
Yes, sir.
And Ms. Salette, what have you offered Mr. Cooper in that regard?
Yes, Your Honor. For the one count of criminal trespass, the state is recommending 12 months served 1 day, credit for time served 1 day, balance suspended, stay away from all MARTA locations. The factual basis for that, Your Honor, on December 2nd, 2022, MARTA PD officers asked the defendant to leave the 5 Points MARTA station at 30 Alabama Street, Atlanta, Georgia, in Fulton County. They asked him to leave several times if he was not taking a bus or a train. The defendant refused to leave the property. The defendant was asked by multiple officers at different times of the day, and it's been an ongoing issue for them. Nothing further from the state at this time.
All right, Mr. Cooper, it's my understanding that in case 22 CR 008122C, you wish to plead guilty to criminal trespass. Is that correct?
Yeah, man.
Are you under the influence of any drugs or alcohol this afternoon?
Nah.
You understand? You're not under the influence of any drugs or alcohol this afternoon, are you?
No, sir.
Okay. You understand that you have a right to counsel, and it's my understanding that you have given up your right to counsel. Is that correct?
Correct.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury? You don't want a jury trial, do you, Mr. Cooper?
No, sir.
Okay. Did you go through the plea paperwork line by line, sir?
Yeah.
And did you sign your name at the bottom of the plea form?
Yeah.
And did you do that voluntarily? Did anybody coerce you to plead guilty to this charge?
Yeah.
So you're doing this freely, is that correct? Of your own free will?
Yeah. Yep.
Okay. And did anybody coerce you to plead guilty?
No, man.
Okay. And do you understand that if you're on probation at the present, probation could be affected by this guilty plea?
Yeah. Yeah.
Do you understand that if you are not a youth, that your status could be affected by this guilty plea?
Yeah.
I'll accept your plea, Mr. Cooper. 12 months to serve 1 day, credit for time served 1 day, balance suspended. You know you can't go back to MARTA, right?
Yes, sir.
Okay, so if there's a MARTA suspension, you can't go back, but you can go back once the MARTA suspension is lifted, but you can't go while there's a MARTA suspension, okay?
Okay, man.
All right. Good luck to you, Mr. Cooper.
Okay.
Position 4, Mr. Buchanan, he has a private attorney. You're done.
Get up, Cooper.
You're done, Cooper. You can get up.
Get up. Come on, man.
You can pull the chair up, yeah.
Good afternoon, Mr. Buchanan, and tell me the attorney's name. What's your name, sir?
Good afternoon, Your Honor. My name is Stephen Miller. I'm representing.
Oh, Good afternoon, Mr. Miller. Mr. Buchanan, we are conducting this hearing today by video. Do you agree to have your case heard by video?
Yes, sir. Yes, Your Honor.
Thank you. You have been charged in case 22 CR 008119D with simple battery, family violence, 2 counts. Is there a history, Ms. Roberts?
I'm showing 35 cycles, with the last arrest being June 15, 2020 for aggravated assault and terrorist threats in Forsyth. Out of Fulton County. He appears to be on probation out of Fulton County for terroristic threats. 20 SC 177097. Disposition was March 18, 2021, 4 years probation. The other 34 cycle appears to be out of Illinois. Has a 2010 conviction out of Illinois for possession of weapon by a felon and aggravated battery on a government official or employee. A 2010 conviction for possession of a controlled substance out of Illinois. A 2006 conviction out of Illinois for unlawful possession of a weapon by a felon. 2006. A 2003 conviction for theft out of Illinois, and nothing further to add.
Ms. Salette?
Yes, Your Honor. On December 10th, 2021, officers were dispatched to 565 Wells Street in reference to a dispute call. Upon arrival, officers spoke with the victim, Ms. Kenethia Williams, that's spelled K-A-N-N-E-T-H-I-A. Ms. Williams advised that while inside the residence, she was gathering her belongings because she was in the process of moving out. Her live-in boyfriend, the defendant at the time, started a verbal altercation with her. The defendant then became upset and grabbed her by the neck and started choking her. Ms. Williams advised that the defendant let her go, and then he went to the kitchen and grabbed an object and made a stabbing motion towards her. Ms. Williams also advised that before the defendant left the location, he spit in her face. The defendant was not on the scene at the time when the police arrived, and this incident did occur in front of Ms. Williams' minor child. The defendant, as pretrial stated, that terroristic threats conviction from 2021, he was initially arrested for aggravated assault, strangulation, and terroristic threats. He was convicted of simple battery and terroristic threats on that case, to which he is currently on probation. That incident did happen in March of 2021. And then thereafter, about, I guess 9 months later, this incident happened as well, where he is accused of choking a different victim in this case. The state's recommendation at this time is going to be a $7,000 surety bond in total, $3,500 surety bond on each charge. The state would argue that he poses a risk of reoffending and he's a danger to the community. No alcohol, drugs, or weapons while out on bond, no contact with the victim, stay away from the incident location, and a one-day anger awareness.
Thank you. Mr. Miller?
Yes, Your Honor. Regarding his history, first, prior to that 2021 incident, Mr. Buchanan did not have any history in Georgia. He had actually lived here from Illinois for a number of years and was able to stay clean before that. Regarding that incident, I did actually represent him for that. That was a mistake of charging, and quite frankly, it was a little overcharging in that, Your Honor, which is why we got it reduced to that simple battery. In that incident, he was actually the victim, Your Honor, and was shot multiple times in his chest, which I believe he's still kind of suffering some of the residual effects from that. Regarding this incident that happened back in last year, excuse me, I spoke with Ms. Williams, and she actually reached out to me before I even had an opportunity to know what was happening with Mr. Buchanan. She stated that she's willing to sign an affidavit today to get these charges dismissed. Her understanding was that this was something that the police did nothing about. Since that time, herself and Mr. Buchanan have not reconciled, but they are fine with each other. They both moved on. He has no objections to a stay away, as they are really no longer in any contact with each other. That being her, nor is he really in contact with her son as well. At this time, Your Honor, we're just asking for a signature bond.
And
Okay.
Your Honor, for the record, the state just wanted to add that we don't have any, we have no knowledge of anything that counsel has stated that the victim has said. We haven't had any contact with her, so we do not know if any of that is true, what he's saying. Thank you.
Is this,
The officer of the court, that's what I'm presenting. I'm not sure what Ms. Salette's trying to get at regarding that credibility that I'm offering to the court. I understand they've not spoken to her. I'm just offering what we talked about when she called me.
okay, and is this the alleged victim on the line here? That's under the name Victoria Williams, or is that for another case?
That's another case, Your Honor.
Okay, all right. Anything further, counsel?
Nothing for much, Your Honor.
All right, it's gonna be $1,000 good bond per charge, making for a total of a $2,000 good bond. No further contact with Ms. Williams. Stay away from the Wells Street address, and no drugs, alcohol, or weapons while out on bond. All right, good luck to you, Mr. Buchanan.
Thank you very much. Have a good day.
Thank you, Your Honor. May I be-
Yes, have a good day, Mr. Miller. You also, Mr. Buchanan.
Position A, Escobar.
Good afternoon, Mr. Escobar. I'm Judge Eric Morrow. This is the State Court Expedited Accusation conducted by video. Do you agree to have your case by video?
Good afternoon, Ms. Allen.
Yes, good afternoon. Do you agree to have your case heard by video?
Yes, Your Honor.
All right, Mr. Escobar, you have been charged in case 22 CR 008131F with simple battery and battery. Is there a history, Ms. Roberts?
Yes, the defendant appears to have 7 cycles. His last arrest was July 5th, 2018 for battery, family violence, cruelty in the third, and obstructing and hindering person from making an emergency telephone call. I looked at Odyssey. He appears to have 2 open cases from that arrest, 19 CR 000887F, and that is for the battery, family violence, and cruelty. And then the second open case is for hindering person making emergency telephone call. That case number is 19 CR 000888F. He has a 2016 conviction for driving without a valid license, another 2016 conviction for driving without a valid license, a 2016 conviction for driving without a valid license, and nothing further to add.
All right, Ms. Falk?
Yes, Your Honor. This incident happened June 13th of, my apologies, my video just went out. June 13th of 2022 at around 11:50 p.m. at 770 Old Roswell Place. The victim in this case, who is Laura Gonzalez Rodriguez, stated that she was in the parking lot near Big Lots, sitting in a vehicle with her boyfriend, the defendant, who she'd been dating for a month. However, she did state they did not live together, which is why the state removed the family violence that was part of the warrant initially. She stated that the defendant became upset with her as they were sitting outside talking, told her to get out of the car. He then got out of the car, threw her onto the ground, kicked her in the abdomen, which caused her to urinate on herself. At that point, Ms. Gonzalez Rodriguez stated that the defendant told her she had to run away or he was going to kill her. So at that point, Ms. Gonzalez Rodriguez took that advice, ran, and went to the Cloud9 smoke and vape shop for help. Officers, when they did arrive at the scene, saw that Ms. Gonzalez Rodriguez's shirt was visibly torn and she had scratch marks on her chest. They did give her a ride back to that 770 Old Roswell Place address where she said the incident had occurred, where they did observe and recover her belongings, which had been thrown onto the ground. The vehicle that she described being in was also parked with several open bottles of alcohol inside, and the defendant was no longer at the scene. We will say that the officers ended up taking her to a friend's house to stay the night, but she did ID the defendant from a photograph, and that's how identification was made. As the pretrial has stated, he does have 2 current open cases, both for family violence issues. That's that 19 CR 887F case and 88F case. Those involved Miss Laura Garcia, who was his wife at the time, but we believe that is a different person than Laura Gonzalez Rodriguez. There was a $4,500 surety bond set on those cases by Judge Law. Both of them are before Judge Richardson. It says they're both ORCA cases right now on the ORCA calendar, and their last court appearance was in September 2021 for a status hearing, and that's where those cases left off. We will also say they had a 2004 battery, family violence, and simple battery out of Roswell Municipal Court that was also dismissed. And so based on those 3 cases in particular, we do have some serious concerns regarding the level of violence that this defendant has demonstrated. We did attempt to call the victim. However, when we called, we received an answer that stated we had the wrong number, so we were not able to get in contact with her. I would ask the court if we can sound for her today. But the state's recommendation is going to be a $10,000 surety bond. That's going to be $7,500 for the battery, $2,500 for the simple battery, no further contact with Laura Gonzalez Rodriguez, no alcohol, drugs, or weapons. And we are requesting a family violence intervention program due to this being the 3rd open pending case belonging to this defendant that involved some level of violence against women. Thank you. Nothing further from the state.
Ms. Bronstein?
Thank you, Your Honor. Mr. Escobar does qualify. He has lived in Atlanta since 1994, and he has 2 children, ages 13 and 8. He also has a brother who works nearby. Unfortunately, Mr. Escobar is out of work right now and has no money. When he does work, he is a plumber, but as I said, right now he has basically nothing. And as the state did point out, this case is 6 months old. I do understand he has that other pending case, but for the past 6 months, he's been out, and there have been no additional issues. I would ask the judge to take this into consideration. Mr. Escobar did want me to ask the court to consider a signature bond. Also, Mr. Escobar's address that he gave me is different than what's in Odyssey, and I put that in the chat.
Okay, thank you, Ms. Bronstein. For the simple battery, it's going to be a $2,000 good bond. For the battery, a $3,000 good bond, a total of a $5,000 good bond. Stay away from the old Roswell Place address. No further contact with Ms. Rodriguez. I'm sorry, Ms. Falk, I did not sound for her. Ms. Rodriguez, Laura Rodriguez, if you are on the call this afternoon and would like to address the court, now is your opportunity to do so. Having not heard from Ms. Rodriguez, in addition to the no further contact, there's going to be no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Escobar.
Thank you, Honor.
Thank you, Your Honor.
Position 13, Jones.
Good afternoon, Mr. Jones. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Your Honor,
Yes, Ms. Gant.
I do apologize for interrupting. Mr. Jones will be proceeding pro se with the plea.
Okay, thank you, Ms. Gant.
You're welcome.
Mr. Jones, do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, Mr. Jones. You've been charged in case 22 CR 008134B with criminal trespass. You have a right to remain silent, Mr. Jones. Anything you say can be used against you. You have a right to have an attorney present at these proceedings. It's my understanding that we have provided you with a public defender in this matter, but you wish to proceed pro se today, meaning without the advice of counsel, and enter into a plea. Is that correct?
Yes, sir.
Okay. Who's handling this case for the state?
Well, she seems to have disappeared, but it is actually going to be Miss Duncan. She got kicked out of the Zoom, so I will handle it.
Oh, okay, thank you, Ms. Falk.
Not a problem, Your Honor.
Would you just make sure that, since I don't have the paperwork in front of me, what is the offer?
So the offer was 12 months probation, 1 day to serve, credit for time served, balance suspended, as well as a stay away from all MARTA stations.
And is that your understanding, Mr. Jones?
Yes, sir.
And that's what you like to accept?
Yes, sir.
Okay, you could continue, Ms. Falk.
Yes, Your Honor. This incident happened back on December 4th, 2022 at around 12:28 a.m. Officers observed the defendant holding the train at Lakewood Station, not letting it pass. After approaching the defendant, they asked the defendant not to hold the train without an emergency. After that incident, he exited Lakewood Station. Officers received a call from dispatch that the same person was holding the train again, this time at Oakland City Station. They approached the defendant, took him into custody, and while doing a background check, saw that the defendant had a permanent ban from any MARTA property. And so that was the basis of the state's plea recommendation. Thank you, Your Honor.
Mr. Jones, it's my understanding that in case 22 CR 008134B, you wish to plead guilty to criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this afternoon?
No, sir.
You've had the opportunity to be represented by counsel. Is my understanding that you wish to proceed pro se this afternoon. Is that correct?
Yes, sir.
You understand that you have a right to a trial by jury and that by pleading guilty, you're giving up your right to a trial by jury.
Yes, sir.
Did you have the opportunity to go through the plea paperwork?
Yes, sir.
Did you go through that paperwork line by line?
Yes, sir.
And did you sign your name at the end of the paperwork?
Yes, sir.
Did anybody force or coerce you to plead guilty?
No, sir.
Are you giving your plea freely and voluntarily?
Yes, sir.
Do you understand that if you're currently on probation, that your probation status can be affected by this guilty plea?
Yes, sir.
And do you understand if you're not a United States citizen, that your citizenship can be affected?
Yes, sir.
Okay, I'll accept the plea as negotiated, Mr. Jones. You understand that you can't not go back to MARTA. You understand that?
Yes, sir.
Okay, good luck to you, Mr. Jones.
Yo, so Judge, I can ask you a question.
Yes, sir.
So I'll be going home today or tomorrow.
As soon as, if you don't have anything holding you, Mr. Jones, as soon as the jail can process you out, you will be released.
Okay, thank you, sir.
Okay, good luck to you, sir.
All right, y'all too now.
Position 9, Gonzalez.
Come on.
Gonzalez. Disregards, Judge. We're gonna go to position 12, Holmes. Come on, Holmes.
Good afternoon, Mr. Holmes. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Judge.
Thank you. Mr. Holmes, you've been charged in case 22 CR 008133G with simple battery. Is there a history, Ms. Roberts?
Yes, he appears to have 12 cycles, 1 out of Louisiana, 9 out of Texas, and his last arrest was from 2016 out of Texas. Aggravated robbery.
I ain't never been to jail in Louisiana.
Hold on, Mr. Holmes. You have a right to remain silent. Anything you say can be used against you. Let your lawyer speak for you, okay?
His
Thank
last
you, sir.
arrest was Texas from 2016 for aggravated robbery. That was a felony conviction in 2017. He had the 2016 conviction for possession of marijuana less than 2 ounces. A 2014 conviction for burglary. And a 2011 conviction for assault and causing bodily injury. All of those were out of Texas. And the arrest out of Louisiana was in 2008 for manufacture, distribution, or possession of a Schedule I controlled substance. There was no disposition listed, and nothing further.
Thank you. Is this your case, Ms. Duncan? Good afternoon.
It is, Your Honor. What's the position number? My apologies for technical difficulties.
That's fine. Number 12, Mr. Holmes.
Okay, yes, 1 second. In this case, the state is going to be requesting a $2,000 surety, no further contact with the victim in this case, a stay away, 1 day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law. What happened in this case, Your Honor, is there was an altercation between two parties at the MARTA located at College Park Station, 3800 Main Street in College Park, where the defendant admitted to officers that he attacked the victim in this case, which is Xylon Boyd, that's XYLON BOYD, because he believed that Mr. Boyd had robbed him the previous day and that he thought that the defendant was wearing his shoes. However, the victim in this case did state that he does not know the defendant at all and that this was a random attack and that he has never actually seen this defendant before in his life. Given this defendant's history, we do have some concern about the risk of offense and flight risk in this case. The bond is currently set on this case at $1,000 good bond. The state is going to be asking for that increase, given that we do believe that this defendant is a flight risk and given the risk of reoffense, given that this was a violent attack that he admitted to clearly to officers with provoked or being asked any questions. He punched this particular victim and he also was pushing this victim. There were no injuries indicated. However, given that the offense is alleged, we believe that that $2,000 surety is more than reasonable in this case.
Ms. Camp?
Thank you, Your Honor. Mr. Gerald Holmes is 34 years old. He has been in the Atlanta, Georgia area for 6 months. He does not have any family in the area to assist him with bond. Mr. Holmes completed high school. He also studied business administration in college, but he did not graduate. He is currently employed at Pro Cutters. He has been in that position for 3 months. These are allegations which my client denies. He's presumed innocent. He denies having any conviction in 2016. I am requesting a signature bond on Mr. Holmes' behalf. We see here remote contact with law enforcement. We are unopposed to the no contact and the stay away orders. And if Your Honor determines that he isn't eligible for a signature bond, then I would ask that Your Honor leave the bond is set at $1,000. Thank you.
I'm going to leave the bond where it is, $1,000 good bond. No further contact with Mr. Boyd. Stay away from the College Park MARTA station. No drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Holmes.
Thank you, Your Honor.
Position 14, Lance.
Good afternoon, Mr. Lance. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. Mr. Lance, you've been charged in case 22 CR 008135F with battery family violence. Is there a history, Ms. Roberts?
On 5 cycles, all out of New York, with the last arrest being from 2015 for criminal possession of a controlled substance misdemeanor, and that was a conviction in 2017. I'm also showing a 2013 conviction for criminal possession of a controlled substance, a 2008 conviction for criminal possession of a controlled substance felony, and then a 2005 conviction for resisting arrest misdemeanor. All of those convictions are out of New York, and 1 probation violation from 2013. Nothing further.
Ms. Duncan?
Yes, Your Honor. This incident did occur on December 4th, 2022 at 1375 Northside Drive, Northwest. The victim in this case is Jessica Ann Jamin. That's Jamin. It's indicated in this incident, Your Honor, that the victim and her live-in boyfriend, the defendant in this case, Mr. Lance, had gotten into a verbal altercation that turned physical when he battered her after she was trying to leave the apartment. He pulled her back in and pushed her towards the wall. And the result of that push, Your Honor, indicated a a visible laceration puncture in her mouth. And she hit her right side of her cheek on the wall because of that, Your Honor. In this case, we do have some concern about intimidation of the witness. In this case, we were able to speak to this victim, and she does not want to prosecute. However, given the fact that this defendant did cause visible physical injury to this victim in the form of an open laceration in her mouth from pushing her into the wall, we believe that a $5,000 surety bond is more than reasonable due to the injuries alleged in this case and the possible influence that is of concern for the state in this case. We'd ask for no further contact with the victim in this case, stay away from the incident location as it is shared, 1 day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law. It was indicated that the victim would be on the line today. We would ask that Your Honor sound for her when that time is appropriate.
Thank you. Ms. Camp?
Thank you, Your Honor. Mr. Lance Michaels is 39 years old. He has been in the Atlanta, Georgia area for 3 years. He is the proud father of 2 children, ages 13 and 18. He does not share any children with Ms. Jessica Jahman, the complaining witness. Mr. Michaels completed high school. He has 2 years of college. He studied music industry and technology. He is currently employed at Ace Hardware. He has been in that position for 1 year. He strongly denies the allegations and maintains that this is an accident. We did not hear about any prior convictions for violence, Your Honor. Therefore, I'm requesting a signature bond on Mr. Michael's behalf. We are opposed to the no contact and the stay away orders. My client wants to continue having contact, and I did have the occasion to speak to Ms. Jahman, who wants contact, and as I understand that she is here to address the court, Your Honor. Thank you.
Thank you. If Ms. Jahman is on the line, I will need for you to activate your camera. And yes, can you raise your right hand for me, ma'am?
Yes.
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you can put your hand down. What would you like to tell the court?
That this was an accident and I would like to continue having contact.
All right. What did you call the police in the matter?
I did.
And
I
why
did.
did you do that?
Just because we were kind of arguing, but this was honestly, it was my fault. I was trying to just go out the door and we were both had been drinking a bit and I ended up falling. It was actually onto the bed frame. But I'm in the fault with this too. Like, I don't want him to be in trouble.
Has this happened before?
No, it has not.
And are you afraid of him?
No, not at all.
Okay, thank you, ma'am.
Your
Ms.
Honor,
Duncan?
may I ask one question of the witness?
Yes.
In this incident where you received your injury, is it true that you had to get 3 stitches on the inside of your mouth as a result?
Yes, but it's because of the impact of because I fell onto the corner of the bed, and so it caused my teeth to go into my mouth. It wasn't anything from him. Like, he didn't cause the harm. It was because I fell onto the bed.
I am not hearing anything. Are we frozen?
I can hear.
I can hear.
I did not hear a response from Ms. Jahman.
Okay, can you repeat that, ma'am, for Ms. Gant, please?
I said, yes, that's true, but it was caused by the impact of me falling onto the bed. It's not that he physically hurt me at all. It's just because I fell onto the bed. And we were arguing, but I don't blame him at all. And I would not prosecute him at all, press any charges. And I definitely still want contact.
All right, anything further, counsel?
Nothing further, Your Honor.
Nothing from the defense.
All right, it's going to be a $5,000 signature bond through pretrial per the judge. One day anger. You're going to have to mute yourself, Ms. Jahman, I believe. Thank you. 1 day anger awareness, no further violent contact with Ms. Jahman, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Lance.
Thank you.
Position 15, Lovelace.
No, position number 11, please. Courtroom number 3.
Okay. And this is Ms. Hamilton.
Yes.
All right, good afternoon, Ms. Hamilton. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're doing by video. Do you agree to have your case heard by video?
Yes.
Thank you. Ms. Hamilton, you've been charged in case 22 CR 008132G with simple battery. Is there a history?
No, there's not.
They ain't talking to you.
I'm only showing one prior arrest from 1996 for simple battery. That case was dead doctor. And nothing.
Okay. Thank you. Ms. Duncan.
Yes, Your Honor, this incident did occur on November 28th, 2022 at 2 Peachtree Street Northwest, which I believe is the Georgia Department of Family and Children Services building. The victim in this case is the niece of the defendant. We have the name as Aprie Hamilton, APRIE. It is indicated from the warrant, Your Honor, that in this case, the defendant swung at her niece and did make contact with the body of the person at that time. We do have some concern about the risk of reoffense in this case, given that this defendant does have a previous arrest for simple battery. Even though remote, it does show a pattern of behavior. Given that, Your Honor, we do believe that a $2,000 surety is more than reasonable in this instance. No further contact with the victim in this case. One-day anger awareness for alcohol, drugs, and weapons, and no further violations of Georgia law. We were not able to make contact with this victim. Therefore, our recommendation is out of abundance of caution for this victim's safety.
All right, good afternoon, Mr. Lynch.
Yes, Your Honor, thank you very much. Your Honor, Ms. Hamilton is 57 years old. She's lived in Atlanta her entire life. She graduated from Frederick Douglass High School. She has no convictions for anything violent on her record, notwithstanding what we've heard about the case that was dead docketed. She works in housekeeping at the Georgia State Capitol. That's a job that she has had for the last 10 years. She's always done a good job. She is an active member of her community. Judge, the alleged victim in this case is someone who my client had taken into her home to support and always attempted to do the right thing. She has no issue with a stay away order or no contact provision from the alleged victim. Things had not been working out, and she is, I believe, an adult at this point. So she's no longer going to be living with Miss Hamilton. Judge, we would request a signature bond in this case, given Miss Hamilton's lack of a violent history of any kind. She is presumed innocent, and there's a lot going on with this story, but we would just ask that you consider a signature bond, primarily based on her ties to the community and her lack of a criminal history, Judge.
All right, it's going to be a $2,000 signature bond for pretrial, one-day anger awareness, no further contact with Aprie Hamilton, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Ms. Hamilton.
Thank you.
Thank you very much, Judge. May I be excused?
Yes, have a good afternoon, Mr. Lynch.
You do the same.
Thank you. Who do we have next? Courtroom 2, courtroom 3.
Position 15, Lovelace.
Good afternoon, Mr. Lovelace. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Judge.
Thank you. Mr. Case 22 CR 008136F with simple assault. Is there a history, Ms. Roberts?
She has no criminal history.
Ms. Duncan?
Yes, Your Honor, this offense did occur on December 4th, 2022 at 676 Holcomb Bridge Road, which is the KFC. The defendant in this case and the victim in this case both work at that KFC. The victim in this case is Alma Villanueva Carreto. That's ALMA, and last name is CARRETO. It's indicated that in this instance, the defendant punched a paper towel holder above the head of the victim in this case, which caused her to fear imminent physical injury. She stated to officers that the defendant does things like this all the time. He acts randomly aggressive to herself and other co-workers while at work on several other occasions. Officers notated that the victim in this case was visibly shaken by this incident, as described by her physical appearance at the time when speaking to officers. She did state that she wanted to press charges in this case. We understand that the defendant has no criminal history, so the state is going to be asking for a reduction in the preset $1,500 surety bond to a $3,000 signature bond through pretrial service with 1 day anger awareness. Stay away from that KFC and no further contact with the victim in this case. And no alcohol, drugs, and weapons, nothing further.
What was the recommendation as far as was it 2,000?
3,000.
3,000? Any objection to any of that, Ms. Gant?
No, Your Honor, not to the bond, but my client, I believe that he has not been terminated. That is his place of employment. So we would ask for a, I guess, a one-time law enforcement to confirm whether or not he still has employment there. And to stay away if terminated.
Any objection to that, Ms. Duncan?
No objection. We just want to make sure that he is not around this victim at any time.
Okay, well, he can't be around Ms. Corretto, so no further contact, but if he still has a job and he can work his job around her not working there at the same time, and he still has a job, then I'm going to allow him to continue working if Kentucky Fried Chicken is still employing him, so he can have that one-time escort. So a $3,000 signature bond through pretrial, 1 day anger awareness, no drugs, alcohol, or weapons, no further contact, and the escort, one-time escort. Good luck to Mr. Lovelace. Yes, sir. Ms. Gant, I think he has a question about something.
Mr. Lovelace, I'm happy to give you a call, sir.
Yes, ma'am.
Keep your mask up for me. All right, go ahead and have a seat.
Petition number 3 is next, please.
Okay. And this is Ms. Black. Is that right? Yes, good afternoon, Ms. Black. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Ms. Black, you've been charged in case 22 CR 008117C with battery family violence. Is there a history?
One moment. He does not appear to have a criminal history.
Okay. Ms. Salette?
Honor, on December 4th, 2022, officers were dispatched to 2006 Summit Place Drive in Sandy Springs. Upon arrival, they made contact with Mr. Andrew Kala, that's K-A-L-A. Mr. Kala advised that he got into an argument with his girlfriend, the defendant, who he has been living with for a year. He advised officers that the defendant punched him on the right side of his face. Officers observed a fresh red mark on Mr. Kala's face, which was photographed. Officers then spoke with the defendant, and she did admit that they did get into an argument and that she lost her temper and punched the victim in the face. She was placed under arrest at that time. The state's recommendation, due to the nature of the charges and what we know about the cycle of violence, the state is going to be recommending a $4,000 surety bond, no contact with Andrew Kala, stay away from the incident location, no alcohol, drugs, or weapons, and a 1 day anger awareness. And I do believe that the victim may be on the line. I do see someone with the name Andrews, so we would ask that you sound for him when the time is appropriate, Your Honor. Thank you.
All right, thank you, Ms. Salette. Ms. Bronstein?
Yes, Your Honor. Mr. Kala is on the line. And I'll be representing Ms. Black for today's purposes only. She is a full-time student at Georgia State University. She also works full-time As pretrial stated, she has no prior arrests, no criminal history whatsoever. She is 24 years old. She was originally born in New York. However, she moved here when she was a little girl, when she was just 7 years old with her family, and her parents are all local. Mr. Kayla, like I said, is on the line. We are asking for a signature bond in this case, and that there not be a do not return and there not be a stay away and no contact provision, that there just be a no violent contact provision. In this case, he does not want to go forward with the prosecution. He is not afraid of Ms. Black, and he wants her to be able to continue, and he wants them to continue to live together. And I would ask the court to allow him to speak.
Okay, thank you, Ms. Bronstein. Mr. Kayla, if you would like to address the court, I'll need for you to unmute yourself and raise your right hand for me. You swear from the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. What would you like to tell the court?
I just wanted to say, obviously, long story short, we did get into an altercation. It became heated. I was struck by her, but obviously I have no physical damage whatsoever. At this point in time, in hindsight, I have realized that I overreacted. I was just trying to de-escalate the situation. I wanted somebody with some authority to come in, de-escalate, and just let her know that that was not okay. I never wanted to press any charges. All I wanted was just a stern warning to say that the behavior that we had and that we're doing is inappropriate. I never wanted her to go to jail. And I would love for this to, be over with. I didn't want this to happen.
Has this happened before?
Absolutely not. No.
Are you
We've been
afraid
dating
of
for
her?
3 years.
Are you
Nope.
afraid of her?
No,
Okay.
sir.
Anything else, sir?
That's it. Thank you, Your
All
Honor.
right, thank you. It's going to be a $2,000 signature bond through pretrial, 1-day anger awareness, no further violent contact with Mr. Kayla, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Ms. Black. You also, Mr. Kayla.
And Your Honor, will you order a 1-day anger awareness? Are you inclined to order that, Your Honor?
I did order that, Ms. Select.
Oh, I'm sorry. Thank you, Your Honor.
Okay, you're fine. All right, who do we have next?
Position 16, Lewis.
Good afternoon, Mr. Luis. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. You have been charged in case 22 CR 008137J with reckless conduct. Is there a history, Ms. Roberts?
First arrest, he was recommended for a UJR to the jail. Nothing further.
Ms. Duncan?
This is the defendant's first arrest in Georgia. However, from my research, this defendant also has an arrest out of Texas and out of Alabama. There's a 2021 engaging in organized criminal activity arrest in 2021 out of Texas, and a 2013 arrest out of Alabama for carrying a concealed weapon. Given those facts, in this case, Your Honor, it did occur on December 3rd, 2022. The defendant was he entered Lenox Square Mall through the metal detector with a firearm. Officers at the mall at that time told him that he had to it's against the policy and that he had to take the firearm out of the mall. However, he continued to walk through the mall with the firearm, and he was later seen on camera dropping the firearm that he had in his possession inside of the trash can at the Lenox Mall. Officers saw on camera. They followed up with the defendant, and they went into that trash can, and they saw that there was a Glock 23 on top of all of the garbage in that trash can. And at that time, it was loaded, and it was in a holster. And the officers took the defendant into custody at that time. He stated that he threw that firearm in the trash because he got nervous. In this case, we do have some concern about the risk of reoffending, because as indicated by our research in the GCIC, this is not his first issue with firearms at the wrong time. We do have also some concerns about this defendant's ties to the community. It seems that he has a Texas address. For those reasons and the serious nature of having a firearm in the mall and dropping it, around mall patrons inside of a trash can loaded. We're requesting a $5,000 surety in this case. It's currently being held without bond. We're asking for a stay away from the Lenox Square Mall. We're asking for no drugs, alcohol, weapons, or firearms, and no further violations of Georgia law.
Ms. Gant?
Thank you, Your Honor. Mr. Lewis Riley is 29 years old. He is in fact a resident of Texas for the past 7 years. However, he travels to the Atlanta, Georgia area frequently as he does have family and cousins here. Mr. Riley is the proud father of 3 children, ages 8, 3, and a newborn. 2 of his sons, ages 3 and 8, actually live with him. He is the primary caretaker. Mr. Riley completed 12th grade. He is currently an apprentice plumber. He has been in that position for about 5-6 months, and he states that he is now a permanent employee. He is presumed innocent, Your Honor. These are allegations. We did not hear about any convictions for firearms. I am requesting a signature bond on Mr. Riley's behalf. If Your Honor determines that he is ineligible, then I would ask, given that he has never been convicted, for a bond of no more than $1,000. We are unopposed to the stay away. And Your Honor, if I may, he also does not have any prior FTAs, and the fact that he lives in San Antonio is definitely not a reason that he will not come back and answer to these charges. Thank you, Your Honor.
It's going to be a $5,000 signature bond through the jail, stay away from Lenox Mall, and no drugs, alcohol, or weapons while out on bond. Good luck to you, sir. Ms. Gant?
Yes, Your Honor.
Your client has his hand up.
Mr. Riley, I'm happy to give you a call if you have any questions. So I don't want you to make any statements unless it's about your bond. It's a signature bond. You can sign yourself out of jail.
Yes, ma'am. Thank you.
Your Honor,
Yes, Ms. Fault.
I know that there's a no alcohol, drugs, and weapons provision, but in cases that involve firearms, we do also ask that the court specifically state no firearms in the order.
Okay,
I have it.
thank you.
Thank you, Ms.
Position
Bridgewater.
one. I'm sorry. Position 1.
Good afternoon, Mr. Bell. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Tony, you misled Bill, right?
Yes,
Oh, Ms. Bell, I'm sorry.
I thought you said Mr. Bell.
I'm sorry, Ms. Bell. I was in the wrong courtroom. Good afternoon. Do you agree to have your case heard by video?
Yes,
Okay, Ms. Bell, you've been charged in case 22 CR 0081116E with simple battery family violence. Is there a history? Ms. Roberts?
She appears to not have a history. No history came back for her. Nothing.
Okay, Ms. Salette?
Yes, Your Honor. On December 4th, 2022, officers responded to 3927 Dalwhiney Court. That's DAHLWINY Court in Sandy Springs. Upon arrival, officers spoke with the victim in this case, Mr. David Bell, who stated that he and his wife, the defendant, got into a verbal dispute and the defendant slapped him in the face. The defendant did admit to slapping the victim in the face, and their 12-year-old daughter witnessed the incident as well, and stated what she saw to officers as well. Due to the family violence nature of this charge, the state would be requesting a $3,000 surety bond, stay away from the incident location, no contact with the victim, and third-party transfer for the 12-year-old minor child, no alcohol, drugs, or weapons, and a one-day anger awareness. Due to what we know about the cycle of violence, that would be the state's recommendation today, Your Honor.
Has your office spoken with Mr. Bell?
No, Your Honor.
Okay. Good afternoon, Ms. Kim.
Yes, Your Honor. Ms. Bell is actually 44 years old, and she has been here in Georgia for about 25 years, and she has 3 children. They're all minors, 15, 12, and 7, and she's married. She has her parents and siblings here in Georgia. She has ties to the communities, and she's not going anywhere. She does not have an employment, Your Honor. She has been a stay-at-home mother for the last 10 years, taking care of her 3 children and supporting her husband. Your Honor, my client has a bachelor's degree from Michigan University, and her major was human resources. We would like to request for signature on bond. This is her first offense, and Your Honor, she is actually indeed qualified for unsecured judicial relief. So we would like to request for that. Thank you.
And Your Honor, I'm sorry, the statement
Yes,
would
Ms.
like
Saleh.
to add for the record that this incident did just happen yesterday. And so for now, all we have is the warrant. So we don't have a report with contact information for the victim. So we just don't want it to appear or come off as if like the victim doesn't care. We're just not sure because we don't have the contact info at this time, Your Honor.
Thank you, Ms. Saleh. Ms. Kim, did you?
No, we don't have contact information either, Your Honor.
Okay. So it's going to be a $3,000 signature bond through pretrial, 1 day until someone speaks to Mr. Bell. No further contact with Mr. Bell, and stay away from the incident location. She can go back to that location on one occasion with law enforcement to retrieve any belongings that she might have there. There will be third-party transfer of any minor children for visitation, and no drugs, alcohol, or weapons while out on bond. Ms. Kim, if someone speaks to Mr. Bell in the future and they would like to have that modified, or if he would like to have that modified in any way, then you can seek a modification at a later time, okay?
Yes, Your Honor.
All right, good luck to you, Ms. Bell. Who do we have next?
Position 17, Phillips.
Good afternoon, Mr. Phillips. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. Mr. Phillips, you've been charged in case 22 CR 008139H with driving under the influence of alcohol, less safe, operating without lights, and failure to yield right of way. Is there a history, Ms. Roberts?
I'm not showing a criminal history. He's recommended for UJR to the jail.
Ms. Duncan?
Yes, Your Honor. In this case, while we recognize that this defendant has no criminal history, given a review of his driver's history, this defendant has 1, 2, 3, 4, 5, 6, 7, 8, 9, 14 citations going back to 1999. They all involve speeding, improper turning, failure to yield, and instances of that nature, where he pled guilty to most of those offenses, Your Honor. So this defendant does present some danger to other motorists in our county and the other citizens on the road at that time. Given that, Your Honor, in this incident that occurred on December 4th, 2022, Officer Francis was patrolling the area of Warsaw Road near the Brookwood Grill when he observed the defendant traveling westbound out of the parking lot of that grill without headlights activated. The officer at that time continued to follow the vehicle, and he noticed that eventually the headlights were turned on. However, when he noted that when the defendant was leaving that parking lot of 880 Holcomb Bridge Road, he failed to yield to oncoming traffic and crossed over all 3 lanes of traffic, causing the officer to have to use emergency brakes to stop a collision from occurring between himself and the defendant. Eventually, he made a traffic stop on this defendant's car. He indicated that this defendant did have an odor of alcoholic beverage coming from the vehicle. He had trouble concentrating. He apologized to officers for breaking the traffic laws. He stated that he was coming from a Christmas party, and he admitted to having some type of drink at that party. Officers on the scene did indicate that he showed other symptoms like red glassy eyes, as well as the inability to concentrate. Based on the officer's training and experience at the time, they did believe that he was under the influence of alcohol, such that it was less safe for him to drive. He was read implied consent. This defendant did not give a clear answer as to whether or not he agreed to implied consent. Therefore, officers took that as a refusal. Given that, Your Honor, and the concerns about risk of reoffense here, given this extensive driver's history and the danger that was present in this instance with this type of driving, given the circumstances, the state is going to be requesting a $3,000 surety for the DUI and $250 surety for the failure to yield and the failure to use the proper headlights for a $3,500 total surety with no alcohol, drugs, and weapons, no further violation of Georgia law, and no driving. Since this defendant did refuse implied consent, their license will be suspended.
Scanned.
Thank you, Your Honor. Mr. William Phillips is 51 years old. He has been in the Atlanta, Georgia area since 1998. He does have a 25-year-old son in Nashville. He does not have any other family in the Atlanta, Georgia area. Mr. Phillips completed high school. He also has studied electronics technology in college. He is currently employed at an engineering firm as a consultant. He strongly denies the allegations. He's presumed innocent. This is his first and lifetime DUI arrest. I am requesting a signature bond on Mr. Phillips' behalf. And if Your Honor determines that he's ineligible, then I would ask for a bond of no more than $1,500. That would be $1,000 for DUI less safe and $250 for the remaining. And we are opposed to any driving restrictions unless and until his license is suspended. Your Honor, thank you.
Okay, for the DUI, it's going to be a $1,500 good bond. For the other two offenses, $250 good bond each. Makes for a total of a $2,000 good bond total. No drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Phillips.
Thank you, Your Honor. This concludes my business. May I be excused?
Yes, have a good afternoon, Ms. Gann.
Thank you, Your Honor.
You're done. Position 18, Paul.
Good afternoon, Mr. Powell. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. Mr. Powell, you've been charged in case 22 CR 008140Y with battery family violence. Is there a history, Ms. Roberts?
Yes, 7 cycles. Last arrest was October 14, 2020 for battery family violence out of Clayton County. There's no disposition listed. He has a 2020 conviction out of Forsyth County for possession of marijuana less than an ounce and possession and use of drug-related objects. He has an aggressive driving conviction from 2018, one probation violation from 2011, and a 2011 first offender that was revoked for carrying a concealed weapon out of Clayton County, and nothing further.
Ms. Duncan?
Yes, Your Honor, this incident did occur on December 3rd, 2022 at 4410 Stonegate Way. In this incident, the defendant is alleged to have slammed the victim's head into a wall, causing a visible swelling to the front of her forehead in the form of a knot. The victim and the defendant in this case live together. The victim's name in this case is Cameron Crutcher. That's Kameron, Crutcher, Crutcher. In this case, Your Honor, we do have some concern about the risk of reoffense. We have spoken with the victim in this case, and she did indicate that this is not the first time that something like this has happened between them. She said that officers have been called several times, but this is the first time that an arrest has been made. She indicated to our office that she has filed for a TPO on November 1st and is still waiting to hear back. She filed for an eviction for this defendant as well, and he was served, but is still waiting on the courts to execute that eviction. She said that she did in fact have a knot on her forehead and pain in her neck and back. She stated that she is going to the doctors tomorrow. She would like no further contact with the defendant, that this defendant stay away, a one-time escort for this defendant to retrieve belongings. Your Honor, in addition to the risk of reoffense given for the victim's reasons, we did indicate that there is an open battery family violence for this defendant out of Clayton County. I was able to make contact with their Solicitor General's office. That case number is 2020 CR 10142. In that instance, the defendant received a $5,000 bond through the magistrate court. and has continued to offend not only also in a violent nature. For those reasons, Your Honor, and the victim's wishes, we're going to be requesting a $7,500 surety bond in this case. No further contact with Cameron Crutcher. Let's stay away from the incident location. 1-day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law.
Ms. Kim?
Yes, Your Honor, he is presumed to be innocent for both charges, the current one and also the open case that is pending in Clayton County. Your Honor, we would like to request for signature on bond, and he is 30 years old. He was born and raised here in Georgia, and they are actually fiancé relationship. They also have twins who are 2 years old, and yes, they do live together, and the place is actually, it is rented in fiance's name. So we have no objection to stay away or no further contact, as long as we have a third party transfer to see the children. Mr. Powell has been gainfully employed at International Cargo Terminal. He does work there, and he's not going to be qualified for public defender service after today's bond hearing. So he will have to hire another attorney. We would like to request for a signature on bond for this case, or maximum $1,000 good bond. Thank you.
Your Honor, the victim is on the line if you would like to sound for her. It's indicated to us that they do not share any children at this time.
Ms. Crutcher, this is your opportunity to address the court if you would like to. Of course, you're not required to, but if you would like to address the court, I'll need for you to activate your camera, unmute yourself, and I'll have to swear you in.
Can you guys hear me?
I can hear you. Can you activate your camera, ma'am?
Yes, for whatever reason. Here we are. Thank you.
All right. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can put your hand down, Ms. Crutcher. What would you like to tell the court?
We do not share any children together. My twins are 5 years old. He does show a lot of mental instability. He has called the police several times on himself, saying that people were watching my home, so on and so forth. We've only been together for the past 4 months. I've lived at this residence since May 2021. We are not engaged. I do not feel safe at all with him being around my children or around myself. I've never been in any type of situation like this. He is very much so addicted to drugs and also alcohol. Does admit to that. I've tried to help him as much as I can, but I do not feel safe. Again, the police have been called before. Nothing was done because I didn't have any visible marks on my body, but this is not the first time that he has laid hands on me. And I was not at all an aggressor in this situation. And I was just trying to go to sleep. Yes.
Okay, thank you, Ms. Crutcher. Ms. Kim, your client has his hand up.
Yes, Mr. Powell, is it about the children who are not your children, I guess, not biological children, but 5 years old twins? If that was my mistake, because I thought they were 2 years old. If that's the case, it's already talked about, so I would like to strongly recommend you to stay silent about the facts of the case so you do not hurt your case.
All right, it's going to be a $5,000 good bond, no further contact with Cameron Crutcher, stay away from the Stonegate Way address, no drugs, alcohol, or weapons while out on bond. If he has any belongings at that address, there can be a one-time law enforcement escort to retrieve any belongings that he might have there. All right, good luck to you, Ms. Crutcher, and you also, Mr. Powell.
Thank you, Your Honor.
Who do we have next?
Position 19, Ralph Powell.
Good afternoon, Mr. Powell. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Good afternoon. Yes, sir.
Yes, thank you, Mr. Powell. You've been charged in case 22 CR 008141A with battery family violence. Is there a history, Ms. Roberts?
He has 11 cycles. His last arrest was September 28, 2019 for simple battery family violence, criminal trespass family violence, and cruelty in the third degree. The only one that shows a disposition is the criminal trespass family violence, and that was a conviction. He has a 2006 conviction for abandonment of a child and probation violation, a 2005 conviction for destruction, removal, concealment, or transport of property subject to security interest, a 1996 conviction for criminal trespass, a 92 conviction for possession of a firearm by a convicted felon, dangerous drugs and possession of a controlled substance conviction, 1991, and a possession of marijuana less than an ounce conviction in 1986. Nothing's right there.
Ms. Duncan?
Additionally, Your Honor, I did see a battery arrest in 2004. This incident before the court today did occur on December 3rd, 2022 at 860 Parkway Road in Fairburn, Georgia. The victim in this case is Destiny Kagler. That's Destiny, common spelling, last name Kagler. It's indicated in this incident that officers responded to a physical dispute where the victim indicated that her ex-boyfriend, the defendant in this case, had choked her and slammed her on the concrete in front of the location that I just placed on the record. She indicated that he had told her to leave the location, so she was leaving. She had packed her belongings and she had booked her hotel, and he was assisting her with leaving the location when they got into a physical altercation, a verbal altercation that turned physical. And she indicated that she was recording the entire altercation. However, once the defendant noticed that she was recording, he grabbed her phone out of her hand and threw it on the concrete, resulting in the phone being shattered. The defendant did indicate that the victim in this case struck him behind his left ear and left a scratch. However, officers notated that there were no physical injuries deserved on the defendant in this case. The officers noted that the victim's AirPod was on the concrete ground where she had stated that the defendant had slammed her earlier before officers' arrival. In this case, Your Honor, the state is going to be requesting due to the risk of reoffense, given that this incident did occur because there was a dispute between the two parties who have or had a physical relationship in the past, given this defendant's arrests for violence in a violent nature, and the fact that we have not been able to speak with this victim at the time, and out of abundance of caution, we're going to be requesting a $4,000 surety, no further contact with the victim in this case, stay away from that incident location, as we're not sure if she was actually able to get her belongings and leave due to the altercation that had occurred between the parties. 1 day anger awareness, no alcohol, drugs, or weapons, and no further violations of Georgia law.
Yes, Your Honor. Mr. Ralph Powell is 58 years old, Your Honor, and he has been here in Georgia all his life, and he has 6 children total, and one of them, 18 years old, is residing with him, and that place, the incident location, is actually his place, and Miss Destiny Kagler does not reside there. Their relationship is ex-girlfriend and boyfriend. They do not have any more relationships. They don't live together. They have no children together. So we have no objection to stay away nor no further contact. And indeed, my client wants to have no further contact. It was her who came to my client's place without invitation. She came and she was actually trying to attack her daughter who was living with him. Your Honor, he's gainfully employed as a truck driver, and he's been working there a long time enough, and he's not going to be qualified for public defender's service. So my representation will end at the end of this bond hearing. He does have an associate degree from Technical College. He has a diesel mechanic skills, and he also served the Army for our country from 1982 to 1988, 6 years as an Army soldier. We would like to request for a signature on bond, and yet, if your honor is not inclined to give him a signature on bond because of the past history, we would like to request maximum $1,000 good bond, and we are totally fine with a stay away, no further contact, and no drug, alcohol, and weapon. Thank you.
Ms. Kim, you said that you don't object to a stay away, but then you also said that it
Oh,
was.
I apologize. That was my mistake. Yeah.
Okay, so I'm gonna let him go back there on one
Thank you.
occasion with law enforcement to make sure that she's not there, and if she's not there, then he can stay there.
Thank you.
Ms. Duncan?
I forgot to state for the record, my apologies, I omitted, from being slammed on the ground, this victim did receive a large visible abrasion to her orbital area that the officers weren't able to take note of, since we weren't able to make contact with her. And to Ms. Kim's point, we did, the warrant did indicate that they were living together, but as Your Honor has stated, you allow that one-time escort, but given that the state's recommendation, we believe it's more than reasonable. Nothing further.
Ms. Kim, your client has his hand up.
Mr. Ralph Powell, I'll be happy to call you to explain the terms of the bond. Please do not say anything so that you don't hurt your case at all.
All right, it's gonna be a $2,000 good bond. No further contact with Ms. Kegler. He can go to the 860 Parkway address with law enforcement to make sure that Ms. Kegler is not at that address. If she is not there, he can stay there. If she is there, he's gonna have to find a different place to go. No drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Powell.
Sir, one thing, please. That's my house. She doesn't live there.
Okay, so I'm allowing you to go back. I just want to make sure that she's not there, Mr. Powell. So you can go back there, but the first time you go back there, you're gonna have to go with law enforcement so that we can make sure that she's not at that location. If she's not at that location, then of course you can stay in your residence.
You only have access to it, sir. No key, no access, no kind of way, so.
Okay, all right, so then there shouldn't be a problem, right?
Thank you, sir.
Okay, all right. Good luck to you, Mr. Powell.
Yes, sir. Thank you.
Position 20, Price.
Good afternoon, Mr. Price. I am Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Price, you have been charged in case 22 CR 008123H with battery family violence. Is there a history, Ms. Roberts?
The defendant appears to have no criminal history.
Ms. Falk?
Yes, Your Honor. This incident happened on December 4th at 4:30 a.m. over at 5550 Glen Ridge Drive in Sandy Springs. Laura Machado, and I may be mispronouncing that, Machado, Toscan, Toscan, reported that the defendant, who she lives with at the apartment, was arguing with her and struck her, grabbed her, and threw her to the ground. Officers were able to see visible injuries to Ms. Toscan's leg, arm, as well as swelling to the back of her head. Although this is the defendant's first offense, we are concerned, well, one, because of the recency of the event. This happened yesterday at 4:30 in the morning, as well as the fact of Ms. Toscan's injuries being the swelling as well as the visible injuries. We are asking for a $3,000 surety bond, no further contact, stay away from 5550 Glen Ridge Drive, Sandy Springs, 1 day anger awareness, no alcohol, drugs, or weapons. We did try to get in contact with Ms. Toscan. We did call and we were unable to leave a message, and our victim advocate did send a text. So we will ask Your Honor to sound for her. Thank you.
Okay, Ms. Kim?
Yes, Your Honor, Mr. Price is actually recommended for unsecured judicial relief. He is one of the few people who truly qualified for signature on bond, and he is 30 years old, and he has been here in Georgia for the last 25 years, and he has his mother here in Georgia as well. He's a truck driver for the last 8 years, Your Honor. He graduated from high school, and he also has 1 year of college education. Your Honor, they used to live together. However, that place is his apartment. So just like the previous case, I want my client to go back there with a law enforcement officer and make sure that Miss Laura is not there in the case. Hopefully that he can return home. Miss Laura Matacho, my client has no objection to no further contact. They actually got broken up, so there's no reason for them to have any further contact. Yes, and other than that, also my client is expecting that Miss Laura will be probably going back to his parents' place because his parents are coming in to visit her. So we would like to request for a signature on bond for his case. Thank you.
Your Honor, unless she moved out this morning, as of the time that the police spoke to her yesterday at 4:30 in the morning, she was living in that apartment with the defendant.
Okay. It's gonna be a $3,000 signature bond through pretrial, 1-day anger awareness, no further contact with Ms. Toscan. Stay away from the Glen Ridge Drive address. He can go back to that address on one occasion with law enforcement to retrieve any belongings. If Ms. Toscan is not living there, then he can live there. If she does continue to live there, then he cannot live there and will have to find another place to go. No drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Price.
Thank you, Your Honor.
Welcome. Position 21, Stubblefield.
Good afternoon, Mr. Stubblefield. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor. Good afternoon.
Good afternoon, sir. You have been charged in case 22 CR 008127C with criminal trespass and unlawful to possess, display, or use any false, fraudulent, altered identification document. Is there a history, Ms. Roberts?
He appears to have 19 cycles. His last arrest was May 11th, 2022 for financial transaction card theft out of DeKalb County. There is no disposition listed. I'm double checking to make sure that. Actually, there was a disposition listed. It was not presented to the grand jury. He appears to be on probation out of Fulton County for computer forgery and financial transaction card fraud, case number 16 SC 145570. Disposition was September 22nd, 2016, 18 months confinement, 8 years, 6 months probation. He has a 2015 conviction out of DeKalb for possession of meth and giving false names to law enforcement officers. A 2007 conviction for 3 counts of forgery. And he also appears to be a multi-state offender. He has 1 arrest out of Florida from 2007. He has 3 arrests out of Michigan, with 1 being a conviction for breaking. It just says B and E, a vehicle steal property. That was a felony conviction out of Michigan from 2003. And 5 cycles out of North Carolina, a felony conviction from 2008 for obtained property of false pretense. And 2007 financial card fraud conviction out of North Carolina. And then he appears to have an active warrant out of Michigan for illegal credit card use, an active warrant out of Ohio for a traffic case, and then the open case out of DeKalb, and nothing further.
And Your Honor, just to fill in a couple of the blanks, I will say I did also see a 2007 identity theft. He had 2 cases that I was showing convictions for out of North Carolina, in addition to that 2008 obtaining property by false pretense. I was showing a 2007 ID theft, financial transaction card fraud, and use or possession of a card unlawfully in 2007, a conviction for that, and a 2007 conviction for identity theft. I'm also showing that he's been convicted in 2019 under 19 SC 164216 for forgery in the third degree and identity theft out of Fulton County. He did receive 5 years probation on that case, June 24th of 2019. So technically, from my understanding, unless that was terminated early, which I'm not seeing in his history, he would have 2 convictions here out of Fulton County. Oh, I take it back. He was terminated on his probation April 29th of 2021 on that case. So the case we have before Your Honor happened December 4th of 2022 at 6 a.m. at public storage located at 2115 Monroe Drive Northeast. He was observed on camera cutting the lock to one of the storage units. Upon his arrest, the defendant was found in possession of an ID card belonging to Gurcharan Singh, that is Gurcharan, last name Singh, Singh. We are actually still investigating this case and are waiting police reports to determine if we'll be referring any of these charges to the DA's office, because quite frankly, between the breaking into a storage unit and the possession of somebody else's ID card, either one of those could end up being a burglary in the second degree or ID theft. Which this defendant is no stranger to. So as the pretrial has already stated, he has a number of convictions out of North Carolina, mainly for the same kind of thing, identity theft, obtaining property by false pretense. He has those 11 cycles in Georgia, including the forgery first and second degree out of Gwinnett in 2007, a probation violation in 2010, another probation violation out of Gwinnett in 2014, and then those 2 cases, the 2016 and 2019 cases out of Fulton County, again, for that same type of thing, financial transaction card theft and fraud, computer forgery, and ID fraud. So to that end, we're asking for a $2,500 surety bond, $1,500 on the criminal trespass, $1,000 on the possession of ID fraudulent identification, a stay away from 2115 Monroe Drive Northeast, which is the public storage, and no alcohol, drugs, or weapons. Thank you.
Ms. Kim?
Yes, Your Honor, Mr. Mark Stubblefield, he is 41 years old and he's been here in Georgia for the last 20 years. And he says that he's gainfully employed as a computer repair shop. It's called the Tristan Computer Shop. And he's been working there from 2016. He also has a bachelor's degree from University of North Carolina, Chapel Hill. He graduated around 2006. Mr. Mark says Gurcharan Singh is his boyfriend and they have a relationship, and he was having his citizenship card with Mr. Singh's permission because he doesn't speak English that well. He was going to help him out with this transaction, he says that that is all his stuff. Those are not stolen properties, they are his properties. We would like to request for signature on bond, and yet because of the previous histories, if Your Honor is not inclined to give him a signature on bond, we would like to request for $1,000 good bond maximum, and we have no objection to stay away from that public storage, and also fine with no drug and alcohol and weapon. Thanks.
And Your Honor, the state doesn't doubt PD Kim's assertion as an officer of the court, but by any chance is Mr. Singh here to verify any of this?
I have not had any contact with him myself.
Okay, that's all for the state.
Okay, and we don't know whose storage unit, was it a single storage unit that was broken into allegedly?
The lock from a single storage unit was cut. And again, all that the warrant says was that they were able to observe that on camera, that the defendant was engaged in cutting off the lock.
Okay. So for the criminal trespass, it's going to be $1,500 good bond. For the other charge, it's going to be a $500 good bond, makes for a total of a $2,000 good bond. Stay away from the public storage, and no drugs, alcohol, or weapons while out on bond.
Thank you, Your Honor.
Your client has his hand up, Ms. Kim?
Yes, Mr. Mark, unless this is directly related to the bond condition, I strongly recommend you to stay silent so you don't incriminate your case.
Yes, ma'am.
Thank
All
you.
right, good luck to you, sir.
Position 22, Sweets.
Good afternoon, Mr. Sweets. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir. Good afternoon, Your Honor.
Good afternoon, sir. You have been charged in case 22 CR 008126J with battery family violence. Is there a history, Ms. Roberts?
He appears to have no criminal history.
Ms. Falk?
Yes, Your Honor. This happened on December 3rd, 2022 at 5:30 p.m. at 3400 Stratford Road, apartment 4204 in Atlanta. Officers spoke to Ms. Williams, Victoria Williams, common spelling for both, who reported that she was arguing with the defendant, her boyfriend, who then pushed her down the stairs. And that was Ms. Williams' contention at the time to police. She stated that the two of them had lived together for over a year at that address. She also stated the defendant threw out all of her clothing in the hallway and over the balcony and into the streets. Ms. Williams, the officers observed, had bruises on her upper thigh and behind her left arm, which were also swollen, and as well as a broken nail. We did have an opportunity to speak to Ms. Williams, who is here on the Zoom. She stated that she and the defendant are in a relationship. They live together. They share no children, and she does not wish to press charges. She stated that she believes this was an accident. However, at the time when she spoke to police less than 2 days ago, she was saying the defendant pushed her. She also further stated, and this was confirmed by police, that her clothing had been thrown out all over the outside of the apartment, which indicates that there was some kind of altercation going on here and not just simply, her accidentally falling down a flight of stairs. And so the state does have some serious concerns here regarding influencing the witness and as well as a risk of reoffense. We are asking for a $3,000 surety bond, no further contact with Victoria Williams. We are concerned there has not been a sufficient cooling off period, as it is still less than 48 hours from the date of the incident. Also, we're asking for a stay away from 3400 Stratford Road, apartment 4204. No alcohol, drugs, or weapons, and 1 day anger awareness. And Ms. Williams is on the line if Your Honor would like to address her.
Thank you. Ms. Kim?
May we have Ms. Williams go first, Your Honor?
Yes, Ms. Williams, if you would like to address the court, I'll need for you to unmute yourself and raise your right hand for me. Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hands down. Thank you, ma'am. What would you like to tell the court?
I would oppose a no contact and a no return, since me and my boyfriend do live together. We attend the same church together, and so that would be very difficult. It's not that I implied that it was an accident. I just simply stated that I don't feel like Will was intentionally trying to hurt me. So there hasn't been any contact between Will and I since he was arrested, so there isn't any influence there. I would just honestly like to put this behind us and allow us to move forward. He's not a violent person. I'm not scared of him. I'm not fearful in any way. So I'm just kind of ready to move forward.
Has this happened before?
No, he's not physically violent. He's not aggressive. He had gotten into an argument earlier that day with his dad. So I just think that he was, worked up, and that's just what it is. And I just happened to be there.
Did you call the police?
Yeah, my neighbor came outside and I called the police. At that time, he had my phone. The only reason why I had called the police is because I wanted my phone back, just so I could leave and there could be some separation between us both.
Okay. Any questions?
Yes, Your Honor. I do have a couple of clarifying questions based on what we received in the report.
Okay, go ahead.
So Ms. Williams, you stated this incident was in regards to an issue he had with his father, but the police report states that he stated he caught you cheating and was looking through your phone for text messages. Is that right?
Well, he had grabbed my phone when we were walking towards the car. He didn't have any evidence of me cheating. He just had my phone. I wanted my phone back. And so that's where the incident took place, was when he was trying to go down the stairs. And as I reached for my phone, he kind of like pushed me back, and that's how I fell on the stairs. So
So in your attempt to get your phone back, he pushed you and you fell down the stairs. Is that right?
Yeah.
Okay. And at some point you felt strongly enough about this situation that you did in fact get your neighbor's phone to call the police. Is that correct?
Yeah, I called the police because I just wanted my phone back. And then that way I could have left and then we could have cooled down and we could have talked about it. What I'm saying is he's not a violent person. I'm not scared of Sweet. Like I said, we've lived together for the last year. We both are active in our community. We both attend the same church. I'm not fearful of him. There's no sort of intimidation between him and I because we haven't even spoken since he's been in jail. So
go ahead.
So I'm not fearful for myself or him in any way.
Is it correct that he also threw all of your belongings, or not all of them, but your belongings outside of the apartment?
Yeah, a few of my items were outside of the apartment. Not everything, but my clothes were outside of the apartment, yes.
Okay, nothing further. Thank you, Your Honor.
Okay, thank you, Ms. Williams. Ms. Kim?
Yes, Mr. William Switz is 25 years old, Your Honor, and he has been here in Georgia about 2 years ago. He's from Florida. Indeed, he came to Georgia to be a professional football player for Atlanta Falcons on 2021. And after playing football as a professional athlete, he retired and now he's self-employed, and he has a rental cars business. He has been doing that about 2 years, and he has a bachelor's degree from University of North Carolina. And Your Honor, this is his first offense, and they fell down through the stairs, and there's no intention behind whatsoever. This was purely accident. But anyway, we would like to request for a signature on bond since he's qualified, and also he's not qualified for public defender's service. So my representation will end at the end of the bond hearing, Your Honor. Thank you.
Okay. It's going to be a $3,000 signature bond through pretrial, 1-day anger awareness, no further violent contact with Ms. Williams, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Sweets. You also, Ms. Williams.
Judge, repeat that bond amount.
3,000 signature.
Thank you.
Thank you, Your Honor.
Thank you. Am I able to be dismissed, Your Honor?
Yes, have a good afternoon, Ms. Williams.
Thank you. You too. Bye-bye.
23, Vaughn.
Good afternoon, Mr. Vaughn. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, I do, and good afternoon.
Good afternoon, sir. Mr. Vaughn, you have been charged in case 22 CR 008128D with battery, family violence, and battery. Is there a history, Ms. Roberts?
He appears to have one cycle out of Cobb County from November 19, 2020 for simple battery and criminal trespass. That case appears. The criminal trespass, simple battery, family violence were dismissed. The simple battery says not on docket. He's recommended for a UJR through the jail.
Ms. Falk?
Yes, Your Honor. And that simple battery family violence did involve a different victim. In the Cobb County case, we did get a chance to speak with Cobb County to ascertain that. This incident happened on December 2nd of 2022 at 11:25 a.m. at 405 Fairburn Road Southwest. Brianna Amy, B-R-I-O-N-N-A, last name Amy, M-A-M-E-Y, who is the sister of the defendant, stated that the defendant had lived with her for about a week, and at some point he struck her from behind. She described it as a sucker punch in an attempt to get her phone. Miss Amy was observed by the officers to have a knot on her head above her eye. She did state that she was allowing the defendant to stay with her to help him out when she spoke with our victim advocate. She stated this has never happened before, but that due to the incident, the apartment complex will most likely not allow the defendant to return back. She also stated that the defendant will need to retrieve his belongings from the residence, and she wants no violent contact with the defendant. We are requesting a $3,000 surety bond, no further violent contact with Brianna Amy. Also, we are requesting a stay away from that address of 405 Fairburn Road, Southwest Atlanta, Georgia, with a one-time law enforcement escort to retrieve belongings, no alcohol, drugs, or weapons, and one-day anger awareness. Thank you.
Ms. Kim?
Yes, Your Honor. Mr. Vaughn is 27 years old, and they are brother and sister. And my client has 3 minor children, 2, 6, and 8 years old. He is working as a plumbing associate at Home Depot. He's been working there for 4 months, and he's the one who takes care of those 3 children financially. His father deceased, and his mother is here in Georgia. Your Honor, he will be qualified for public defender's office since he does not have much assets except that job that he really want to keep, so that way he can continuously take care of his 3 minor children. If he is ordered to stay away from 405 Fairburn Road, my client will be facing homelessness. He does not have any other place to go to. And we request for no further violent contact. And that's it, Your Honor. Signature bond is recommended. Thanks.
Your Honor, Mr. Amy is here if Your Honor would like to sound for her.
Yes, Miss Amy, if you are on the line and would like to address the court, now is your opportunity to do so. You'll have to unmute yourself and, okay, there you go. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, Miss Amy. What would you like to tell the court?
It is confirmed that he is basically like the mother and father of his 3 children. My brother, I don't know. My brother got a lot going on, and I do as well. And I just wanted him to leave just that night because the previous day it would have been his birthday. We just got into like a disagreement of like some family situation that happened in the past. The only thing about it is I'm like the second oldest sister out of 7 siblings, and I'm adopted, but we have like a lot of family trauma, and I just wish we could all just stick together as one to overcome this. So I just want him to get better as like with this issue, because like I said, he is a single parent. I'm a single parent myself of 4 kids, and I just don't want it to be like no violent type of thing. I just feel like we should all just come together as a family. I know he don't have nowhere else to go. Like my apartment complex didn't say anything to me as of yet of the incident, but I just don't want no violent contact at all. That's it.
Okay, so you all of you live at the Fairburn Road address, is that right?
That's correct, sir.
Okay, and you're telling this has this happened in the past?
No. This is his first time living with me, but due to him being homeless, and he got the Home Depot job, so he can support not only his kids but try to help me out as well at times because I suffer with a heart condition.
Are you afraid of him?
No, sir.
Okay, and both you live there with
my 4 kids,
Mr. Vaughn, your children and his children at the present time. Is that right?
Well, they come over. The moms have custody of his kids, but they do come to spend time with him and stuff like that.
Okay, all right, thank you. Ms. Falk, anything?
Nothing further for this witness, Your Honor. Thank you.
Okay, Ms. Kim, anything?
Nothing further, Your Honor.
Okay, so for the battery, family violence, a $3,000 signature bond through pretrial. For the battery, a $2,000 signature bond through pretrial. 1-day anger awareness, no further violent contact with Ms. Amy, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Bond and Ms. Amy.
All right, thank you. Can I be released? You know?
Yes, have a good afternoon, ma'am.
You too.
24, Whitaker.
Good afternoon, Mr. Whitaker. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Good afternoon. Thank
Good afternoon. Yes, good afternoon, Mr. Whitaker. And is that a yes, that you do agree to have your case heard by
yes.
video?
Yeah,
Okay.
it's fine.
All right, thank you, Mr. Whitaker. You've been charged in case 22 CR 008129J with criminal trespass. Is there a history?
Give me one moment, please. He
I'm
does
sorry.
appear to have one cycle, which was December of 2000, out of Gwinnett County for forgery in the first degree. That was a first offender and it was sealed in 2001. And he is recommended for a UJR through the jail.
Ms. Falk?
Yes, Your Honor. State's recommendation is a $2,000 signature bond through pretrial stay away from the Georgia Tech campus at 965 Fowler Street, Atlanta. No alcohol, drugs, or weapons. In short, this defendant was seen on December 3rd at 4 o'clock in the morning, standing outside the doors of McCamish Pavilion, which is their indoor sports arena. He was asked for ID, and when the officer ran his information, he saw that the defendant had an active criminal trespass warning until March 23rd, 2023 to stay away from that area. As the pretrial has said, this is his first official offense since his previous offense was sealed under first offender.
So is the stay away from the Fowler Street address?
We're asking for a stay away from Georgia Tech campus.
Georgia Tech
My
campus.
understanding is the criminal trespass warning was active for Georgia Tech campus. So I don't think they had any restriction as to a specific area.
Okay. It's gonna be a $2,000 signature bond through the jail and a stay away from the Georgia Tech campus. No drugs, alcohol, or weapons while out on bond. Does that suit you, Ms. Kim?
Yes, Your Honor.
All right, good luck to you, Mr. Whitaker.
Thank you.
25 Williams.
Good afternoon, Mr. Williams. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir. Good afternoon as well.
Thank you, Mr. Williams. You've been charged in case 22 CR 008130A with simple battery family violence. Is there a history, Ms. Roberts?
I'm showing that the defendant had 6 cycles. The last arrest appeared to be September 11, 2019 out of Cobb County for 2 counts of willful obstruction of a law enforcement officer, theft by receiving stolen property, and fleeing or attempting to elude a police officer. That case, some of the charges appear to be a conviction. The willful obstruction of a law enforcement officer was a misdemeanor conviction, theft by receiving stolen property, and fleeing or attempting to elude a police officer with both felony convictions. He appeared to be on probation for the theft by receiving stolen property. It was a 5-year probation sentence from August 10th of 2020. He also appears to be on probation out of Cobb County for possession of a firearm by a convicted felon and fleeing or attempting to elude a police officer. His disposition date was September 21st, 2017, 10 years probation. He has a 2004 conviction for crossing state or county guard lines with weapons, intoxicants, or drugs without consent, and possession of marijuana less than an ounce. That was in Sumter County. A 2001 conviction for armed robbery. That was with Chattahoochee Judicial Circuit. And then a 1998 conviction for a motor vehicle offense, and nothing further.
Ms. Falk?
And Your Honor, on those 2 Cobb cases, we are showing that in the 2017 case, he got a 5-year prison sentence. And in the 2020 Cobb case, he got a 2-year prison sentence on top of the probation that he was also sentenced to. This happened yesterday at 1:16 p.m. at 2069 Detroit Avenue Northwest, Apartment A in Atlanta, Georgia. So the officers actually got a dispatch for a 911 call where the line had remained open, and the 911 dispatcher had reported that there sounded like there was an ongoing fight that was actively happening, and they could hear the caller stating that she was being physically assaulted. When the officers did get there, they spoke with Lucretia Williams, that is LACRESHA, last name common spelling, who stated that she could handle the issue with her husband. She explained that to the police that she had called the police on him in the past and nothing was done. So at that point, she felt like she just needed to handle it herself. After being reassured by the officers that they would take action if she told them what happened, she proceeded to tell them the defendant had slapped her after arguing with her about having a friend come over to the home. We did get a chance to speak with Miss Williams. She and the defendant are married, live together, and share no children. She did confirm what was stated in the police report, that this is not the first time that this has happened. However, she also stated, as it was confirmed in the police report, this is the first time that he had been arrested by the police for something like this. She further stated she has called the police on the defendant before. The officers did not do anything. She has asked for no violent contact with the defendant. We are asking for no further contact whatsoever, given the fact that there is information both in the police report as well as our conversation with the victim advocate to indicate that this has been an ongoing issue of violence in the home. She does not want him to return back to the residence. We are in full agreement with that, and also asked for a stay away. And she stated that the defendant will need a one-time law enforcement escort for retrieving his belongings. Based on his history, which includes, as you've heard, 2 prison sentences and an armed robbery, we are asking for a $3,000 surety bond, stay away from 2069 Detroit Avenue Northwest Apartment A, no further contact with Lucretia Williams, no alcohol, drugs, or weapons, and 1-day anger awareness. I'm not sure if Miss Williams is on the line, but the state would ask for the court to sound for her.
Thank you, Ms. Kim.
Yes, I would like to have Miss Lucretia Renfro go first.
Okay. All right. Good afternoon, ma'am. Can you activate your camera for the court?
Yes, hi.
Hi, good afternoon. Raise your right hand for me. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Yes, ma'am. What would you like to tell the court?
I would like no further, I would like no non-violent contact with him, far as that, because we still got to go through our divorce and everything like that, far as that goes. But far as him coming to get his things, I would like him to come get his things and he can go on about his business.
Okay. Anything further?
I'm gonna drop the charges, but long as they come escort him to come get his things, he can go ahead and go peacefully, go his way, and I'll go my way, because we still got to sign our divorce papers. We still got to go through the divorce thing or whatever, but I want him gone.
Okay, so what I'm going to do, Ms. Renfro, is that now that we're at this position, it's up to the state to drop charges, so the charges will remain intact. I don't think it's a good idea at this point in time if you all have any contact, so I'm going to order no further contact. He can have a one-time escort to get his belongings and things and you'll just have to deal with your divorce through your attorneys. But at this point in time, I don't think it's going to be a good idea to have any further contact and I'm going to order a stay away, just so you know before we go forward. Okay. All right. Thank you, ma'am. And Ms. Kim?
Yes, Your Honor. Mr. Rodney Williams is 43 years old, and he is Atlanta native. He's been here for 43 years. He has 3 children. With Miss Lucretia, even though they live together in a marital property, they do not have biological children together. He just has a stepson who is a biological child of Miss Lucretia. And my client does not have any objection to stay away or no further contact at this point. He has been working as a tattoo artist for the last 8 months, and he has up to 11th grade at the high school, and he got GED. And also, Your Honor, he has 3 adult children and 4 grandchildren. He has been incarcerated for a long time for other charges. I think he had enough problem. He currently has a heart problem, Your Honor. So I would like the court to consider his medical condition. We would like to request for signature on bond, and yet if your honor is not inclined to give him a signature on bond because of histories, we would like to request maximum $1,000 good bond. Thank you.
All right, it's going to be a $3,000 good bond. No further contact with Ms. Williams. Stay away from the Detroit 2069 Detroit address. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Williams. You also, Ms. Winfrey.
Your Honor, can we get the reset date on that? I'm sure Ms. Bridgewater said that at the beginning, but I did miss it.
Oh, that's fine. It's December 20th.
Thank you, Your Honor.
The next court date will be December 20th.
Yes, if he does not get out of custody, the next court date will be December 20th.
Okay.
So that was a $3,000 good bond?
That's correct, Ms. Bridgewater.
Position
All right.
9, Gonzalez.
Tell me again.
Position 9, Gonzalez.
Okay, thank you. Good afternoon, Mr. Gonzalez. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're doing by video. Do you agree to have your case heard by video?
Not a problem.
All right. Thank you, Mr. Gonzalez. You've been charged in case 22 CR 008124E with willful obstruction of law enforcement officers. Is there a history, Ms. Roberts?
He appears to have 24 cycles. Last arrest was November 22nd, 2017 for 2 counts, FTA, giving false name, and willful obstruction of a law enforcement officer. That case was, there's no disposition enlisted for that case. He has a 2017 convictions for drugs not in an original container out of Fulton County. He has 4 cycles out of Georgia, the other 20 out of New York. He had a 2012 conviction out of New York for resisting arrest, a 2012 criminal trespass conviction out of New York, a 2010 conviction for obtaining transportation without paying, a 2010 conviction for intent to obtain transportation without paying conviction, 2009 criminal trespass out of New York, a 2009 intent to obtain transportation without paying conviction out of New York, 2008 criminal trespass conviction, 2006 criminal trespass conviction, another 2006 criminal trespass conviction, 2004 criminal tampering, 1998 criminal sale of a controlled substance, that's a felony conviction. 1991 sale of a controlled substance, narcotic drug, felony conviction, and then a sale of a controlled substance, felony conviction, 1991, and all of those are out of New York, and nothing further.
Thank you, Ms. Salette.
On December 4th, 2022, Officer Jay Zachary with the Atlanta Police Department was dispatched to 355 Peachtree Street. That's the Imperial Hotel around 4:30 p.m. Initially, the call came from an unknown female saying that there was a dispute at the location. Officers went out to the location and went to the room in question. And outside of the room, they heard loud thumps and yells. As they got closer to the door, they heard more thumps. They got louder. After waiting, after the officers got to the door and knocked on the door, the defendant opened the door. Officers asked if everything was okay. And the defendant stated that everything was okay and blocked the door and would not allow officers to come in to speak with the female who had made the 911 call. Officers continued to ask the defendant to step out of the way so they could speak with the other occupant of the room. The defendant would not allow them to come in. At that time, officers warned the defendant that they were going to detain him because they were hindering officers from their investigation of the incident. Officers attempted to handcuff the defendant They were only able to get one arm, and the defendant just kept not following the commands of the officers. The officers eventually had to tase the defendant, and at that time, he did become cooperative and did allow officers to handcuff him. Officers were able to speak with the female who they believe called 911, and she stated that she was having a seizure. And the state would argue that if she was in fact having a seizure, that the defendant would have welcomed any help from the authorities. But the defendant was arrested at that time. Due to the victim's history, I also was showing a failure to appear arrest from 2017. The state would argue that the defendant does pose a risk to the community and to reoffending, and that he might not appear for court in the future. The state's recommending $1,000 surety bond and to stay away from the incident location, no alcohol, drugs, or weapons. The report and warrant did not mention the female's name, so we do not have a name for no contact at this time.
Ms. Bronstein?
Thank you. Ms. Willett, what was the incident location, the address?
The address?
Yes.
Second.
355 Peachtree Street?
Atlanta, yes, that's what I have.
Okay, so that's his home. Okay. So I will be representing Mr. Gonzalez for the purposes of today, not that he necessarily does not qualify, but we just don't have all the information at this time to make that determination. Mr. Gonzalez is 51 years old. He is originally from New York City. However, he moved to Georgia over a decade ago because his mother lives here. His wife and his 2 children, age 6 and 7, live here. He does have some college education. However, at this time, he is unable to work and cannot make any bond. Would like to point out this is the only charge is obstruction. The officers did not find probable cause of any other charges. There are no other charges. Whenever there's just an obstruction charge, it's always a very weird situation. And I would like the court to take all of that into consideration and set a signature bond for Mr. Gonzalez. And also to not do a do not return. There is no evidence of any violence, any nefarious activity.
Is that Ms. Bronstein? Hello, can you all hear me?
Yes.
Okay, so it's Ms. Bronstein that's gone out.
Any other charge. So there's no reason to keep him away from his home.
Okay, it's $1,000 signature bond through the jail, no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Gonzalez.
Thank you very much.
You're welcome.
Judge, I just have a quick announcement for position 6 is going to be a medical reset. And also position 10, waive their appearance, and then we're completed here in Portland too, Judge.
Okay, we're gonna reset that for tomorrow. We're gonna reset that for tomorrow.
Yes.
Okay, so that's 12/6. And we have a waiver on Mr. Hagan.
I'll waive an appearance. He doesn't qualify for the public defender's office. However, for the purposes of today, we do represent him, and he asked to waive his appearance, and we'll also waive sounding of the charge.
Okay, I'll see you tomorrow.
Thank
Y'all
you.
have a good afternoon. Thank you all.
You too. Thanks. Bye-bye.
And Your Honor, the report in this case does indicate that there may be some MH issues here. I'm not sure how defense counsel would feel about a breakout room for this case. I don't know if she's had a chance to speak with her client in regards to any possible diagnosis.
I have spoken with him. We could do a breakout room. That's fine.
Okay.
But I won't be representing him going forward. I know he came from the hospital.
Okay, so if you all want to go to a breakout room, we can go to a breakout room. If there's a mental health issue. Okay, so if you'll put us in a breakout room, please? I'm going to step away for just a moment. I'll be with you.
Oh, boy.
Okay, so, for Mr. Hagan, position number 10, we've had a discussion in the breakout room. The breakout room was because of a discussion of the mental health of Mr. Hagan and not for any other reason. It's going to be a 5 bond. Stay away from Grady unless he's there for medical treatment. No further contact with and no drug, alcohol, weapons while out on bond, and he's to have a social worker visit who's to report to me if he does not get out of custody on December 20th at the SAP calendar. It was also representation was made that he does have some adult children who Ms. Bronstein is going to try to contact after this hearing today. Did I miss anything? Okay. All right, so whenever you're ready, Ms. Bridgewater.
Yes. Once again, the reset date for the SAP calendar is going to be December the 20th. Position number 1 is, and let me state this. I was advised by pretrial that all of the cases going to pretrial are per judge.
Yes, I understand that something's going on that I've not been made aware of prior to this court hearing today. So whatever I placed with pretrial would be per the judge.
Okay.
And maybe someone will tell me before the next court hearing why that is.
Okay. So
Okay.
now that I know, sure. Okay, position number 1 is reset further notice with a $3,000 SOB through pretrial. Position number 2 is reset further notice with a $2,000 SOB through the jail. Position number 3, reset further notice with a $2,000 SOB through pretrial. Position 4 is going to the SAP calendar with a $2,000 total good bond. Position 5 is reset to the SAP calendar with a $1,000 total good bond. Position 6 will be reset till tomorrow. Position 7 took a plea. Position 8 going to the SAP calendar with a $5,000 total good bond. Position 9 reset further notice, $1,000 SOB through the jail. Position 10 reset to the SAP calendar with a $5,000 good bond. Position 11 reset further notice with a $2,000 SOB through pretrial. Position 12 reset to the SAP calendar with a $1,000 good bond. Position 13 took a plea. Position 14 reset further notice with a $5,000 SOB through pretrial. Position 15 reset further notice with a $3,000 SOB through pretrial. Position 16 reset further notice with a $5,000 SOB through the jail. Position 17 going to the SAP calendar with a total $2,000 good bond. Position 18 going to the SAP calendar with a $5,000 good bond. Position 19 SAP calendar, $2,000 good bond. Position 20 reset further notice with a $3,000 SOB through pretrial. 21 SAP calendar with a $2,000 good bond. 22 reset further notice with a $3,000 SOB through pretrial. 23 reset further notice with a total $5,000 SOB through pretrial. Position 24 reset further notice with a $2,000 SOB through the jail. And position 25, a $3,000 good bond reset for SAP. Are there any questions, comments, or otherwise?
Yes, for position 14, Ms. Bridgewater, what are the conditions attached to that $5,000 signature bond?
Okay, let me get to it. No further violent contact with Jessica Jamin in a 1-day anger management, along with no drugs, alcohol, weapons, or firearms.
Thank you so much.
You're welcome. Are there any others? Okay, let's run home today, okay?
Y'all be safe. Great. Yeah.
Have a good evening.
We'll see y'all tomorrow.
Okay,
Thank you.
bye-bye.
It's not so bad, Ms. Bridgewater. It's only 4:30. We did good, right?
We did good. We
Yeah,
did
for
good.
for 25 people, you know?
I think we did real good.
All right.
I'm getting ready to send this to you, okay?
I'll wait to hear from you. Okay, thanks.
Okay. Hey, did you enjoy Founder's Day?
I did.
What you do?
know,
What did you do? You call your LB?
We up here live on YouTube. I'll call you later.
Oh, I thought we were